Welcome to another episode of Quick Thoughts. Today we shall speak on the topic of legal reasoning. Is there a formula for legal reasoning? Legal reasoning is like your bone structure. Nobody can see it, but it is your skeletal structure that is holding up your hands, your head, your brains, your thoughts. And parts of the skeletal structure is connected to the brain. This is a structure that has been created over many years of practice. Let me tell you what it is straight away. It's called FILACR. F-I-L-A-C-R. F stands for facts, I stands for issue, L stands for law or legal principle, A stands for application of the law to the facts, C stands for conclusion, R stands for relief. So let's dive in straight away into a scenario. Suppose you represent a defendant who's been accused of assaulting the victim. The victim says he's been assaulted by your client. Do you know what an assault is? There is a difference between assault and battery. Battery is the actual application of force, whereas an assault is the creation of a worry or a fear or an apprehension of an attack. F for facts. You must establish when you're interviewing your client, isn't that the first thing that you will do? Client comes to you and says, I'm accused of assault. First question you'll ask yourself is, alright, where did it happen? Facts, not any old facts, relevant facts. Where did it happen? At what time did it happen? What were you doing before that? What were you doing after that? Did you hit him? No. Did you slap him? No. Did you have a hockey stick in your hand? No. Then why is he accusing you of assault? Well, you see, he tried to tackle my sister. He came to the house to disturb her. I went outside and I scolded him. Then other things happened. He went to the police, I was arrested and they charged me. I see. So establish the facts. What is the date this happened? Next, issue. What is the issue? The I in the FILACR. Issue is, did Mr. X assault Mr. V? That's the issue. So let's see how we can make this work. The issue is, did he assault? So for you to determine the issue, you have to look at the law. What is the law of assault? It is an act. It must cause fear of immediate harm, and it must create in the mind of the victim a feeling that he is going to come to harm. So now you're going to apply the FILACR formula and you're going to cross-examine him. First in your head is F. So you ask the victim, when did my client assault you? On this date. What date? 29th of February 2020. 29th? No, it's the 30th of February, I think. How is it 30th of February? Because that's the third birthday of my daughter and I celebrated it. It happened on that day. So you know that he's already made a mistake. Be quiet. Don't make a big hash of it. Next question. What act did my client do? Did he raise his fist? No. Did he slap you? No. Did he have a weapon in his hands? No. Did you have this fear? His lawyer would have told him, make sure you say that you are afraid. So you know he's going to say he's afraid. FILACR, F-I-L-A. L stands for law or legal principle. A stands for application of the law to the facts. You're applying the law to the facts. Then you ask him again. So while he was assaulting you, you were exerting force on my client and he fell backwards, didn't he? I can't remember. He's not going to tell you anything. So given the facts that my client had injuries on his hands immediately after the quarrel that both of you had, and there was nobody else within 50 feet of you, the only presumption is you attacked him, not he attacked you. I can't agree with that. Obviously he's not going to agree with you, but you've applied F-I-L-A-C. So the judge is watching and she is looking for the C, the conclusion. What's the conclusion? Your client didn't assault him. So you don't have to put the final question to the witness and say, so therefore, you were not afraid, were you? You don't have to ask that. So you go during arguments, final submissions, when you're wrapping up, you tell the judge, these are the facts, these are the issues, this is the law, this is how I applied the law to the facts during cross-examination, and the only conclusion, Your Honor, my lord, my lady, that you can come to is my client did not assault this person, and therefore the relief are, please acquit him. Thank you very much. Thank you for staying with me for so long. Please like if it was interesting, subscribe, comment, share with your friends, and this is GK TV.